slide.
Good morning, please be seated. Welcome to the First Court of Appeals. We have one case on our oral argument docket today. The case is Robert Aaron Rosales versus State of Texas. And let's have announcements. Appellate, you ready?
Jonathan Langer is here for Mr. Rosales.
Very good. Appellee. And counsel, would you like any time reserved for rebuttal?
Yes, Your Honor. 5 minutes. I think they've got it on the clock.
That sounds great. I will not explain to you what the clock means and how a yellow light works. I think you can figure that out for yourselves. What I will do that is a little bit different is give you both a 2-minute opening in your principal argument where you won't be questioned, where you can make any pitch you want. Some of the courts around the country are trying this. The United States Supreme Court is trying it because they're very active with questioning, and it's sometimes useful to counsel to be able to make an elevator pitch for a couple of minutes. So let's do that. I predict that we will be questioning both of you at some length, and so I want to make sure that you are fully heard before you go home. So with that, we're ready to hear from appellant.
May it please the court. I'd like to thank the court for this opportunity to come and discuss these important issues today. I do think they're important. I think they're unique based on the facts of this case. And this case involves the intersection of the Fourth Amendment, emerging technologies, and emerging police practices. Of course, the underlying offense is a child pornography case, but this is not a child pornography case. The same principles that are going to be discussed here today can take place involving political speech, religion. It's a case about the protections provided by to all of our citizens by the United States Constitution. And I appreciate the 2 minutes, but I'll welcome any questions if they pop up during this time. When I initially started briefing this case, I didn't expect to have to discuss standing, quite frankly. I thought that it was taken care of without a doubt at the lower court. The question is, does Mr. Rosales have a reasonable expectation of privacy in his Dropbox account? The only evidence below about whose account it was is this belonged to Mr. Rosales. Mr. Wilson, Officer Wilson agreed as much. The state's questioning of Officer Wilson, I thought, was a stipulation that there was standing. They did argue whether or not he consented to the search of his property based on the click wrap agreement from Dropbox, but nowhere was standing argued. I don't think it's a stretch to agree that we all have a reasonable expectation of privacy in our online files if the facts are we have not shared them with anybody and they're password protected. So with that, I'm going to leave standing and I'm going to move on to the burden issue for issue number 1, which the argument is the state failed to meet their burden in establishing an exception to the warrant requirement. And this will be the only time that I discuss the withdrawn opinion in this argument, but the law is clear in Texas and the United States. Whenever you have a warrantless search, well, first of all, the burden is on the defendant to establish a warrantless search. Officer Wilson was clear, it's even in the search warrant affidavit, he reviewed these files, these 8 files from Dropbox without a warrant.
Let me pause you
Yes.
on that. I waited.
No, I appreciate it.
But Talking about the burdens.
Yes.
It is my understanding that in Burwell, our court said the defense bears the burden in terms of showing the private actor, and the question is maybe still open about the exceeding the scope. Do you agree with that?
No. So the initial burden, I think it's clear from the treaty side in our motion for a hearing that were filed, I'm assuming that's still before the court, that the initial burden on a defendant, and the case is Russell v. State, it's a CCA case, the initial burden is to show a warrantless search.
Okay, and doesn't it really then turn on whether there's a search at all? If the private party doctrine applies,
Right.
then there is no search.
So the way it would go here is then you have the private party exception to the warrant requirement. Which
Is it an exception to the
It
warrant
is.
requirement, or is it just that there's no search
I think if you
by the
look
government
at,
at all?
I think if you look at the Wilson Ninth Circuit case, the Ackerman case also discusses it. I think it's pretty clear, and also the Jacobson, I hope I'm saying that correctly, case from the
The
Supreme Court.
1984.
Yes, I believe that it's an exception to the warrant requirement. That the burden would fall on the state to prove the exception. Now, if they prove it, then the burden comes back to us to show why it should not apply. Here, that would be the agency test. So we do have shifting burdens as this goes along. With
So
that,
then you would
go ahead.
say you were acting as a government agent, or you would say, you're saying that would be your burden?
That part would be. So step number one is, has the state met their burden of an exception to the warrant requirement here, the third party search doctrine. So I'd like to start there.
Let me
Go
just
ahead.
pause you to come back even
Of
further
course.
for 1 second.
Of course.
Very briefly touching on standing that you raised before.
Okay.
Whose burden, is it your burden to show, who had to get the proper
That would
agreement
be-
in the record?
That would be our burden.
So if there's an agreement in the record, but we don't know if it's the applicable agreement, and it's your burden, what does that mean?
This court doesn't even have to rely on the burden. I want to be clear about that. You can rely on the facts of this case. Officer Wilson tells us it's Rosales' Dropbox file. He tells us none of the files in there were shared. No evidence. It's not one of these cases where it's a public Dropbox where multiple people can go in there. None of the files are shared. Officer Wilson says this is a password protected Dropbox account. That's his understanding. Also, in the search warrant affidavit itself, Officer Wilson says there's a reasonable expectation of privacy in Dropbox accounts. He says the same thing at the hearing. And on page 75 of the record, when the state, I guess a recross examination of Officer Wilson, he agrees that he has to get a search warrant in order to search a Dropbox account. So you can rely on the facts. You don't have to rely on that stipulation. I was just caught off guard that we didn't have an agreement. That's merely all I was pointing out here.
Okay, sorry. Thank you. Please proceed
Okay.
to discuss the
So,
private search doctrine.
Moving on to the private search doctrine. And I'll be honest, as I've reviewed these cases over the past few days, I've realized that the question is not merely what scope did the private party search entail. Okay, it's not just a question of scope. It's also a question of what the government actor knew about the search, what information they had at that time.
Okay, so let me pause you
Go ahead.
on that. So the test is there's an intent prong and there's the knowledge and acquiescence prong.
It really boils down to what the police knew at the time they initiated their search, and did their subsequent search give them more information? That's really the question. I've got just a few quotations, very short, that kind of tease this standard out. First of all, there has to be a virtual certainty that review of the videos would not tell him anything more than Officer Wilson already knew. That comes from the Jacobson case. Okay?
What does review of the videos mean? What does it mean if I say to you, Dropbox or Google or Adobe reviewed files?
Right.
I don't say John Doe or Fred Smith. I
Right.
say Google.
Yes.
What does that mean?
Well, so the first part of this test is what was the scope of that initial search, all right? If you look at your case, I think it's Burrow, that's the way to say it. There, the evidence was clear. Whatever officer, I think it's the same Officer Wilson, whatever he did was the exact same thing that, I think it was Google in that case, one of the service providers. It was the exact same, it was Adobe. It was Adobe. He did not go any further. He also said, I did not go any further than what NECMEC did. That's the difference with this case. I specifically asked Officer Wilson, what did Dropbox review? He said, I know they laid eyes on it, but I don't know that they reviewed the entire
Okay,
video.
hold on.
Go
So,
ahead.
number one, we're talking about the exceeding the scope. We've moved on from whether this was a private party. So there are two different angles we
Right.
need to be looking at. If we're on the exceeding the scope, in this record, the tip says that Dropbox viewed the entire contents of the files.
It does say that.
So how could there aren't other files?
Well, I think
An issue.
I think the first issue, and I just got the report here with me. It does say, yes, we've reviewed the entire file. It's also got apparently false information in there
Right.
that the contents of the uploaded files were publicly available. Officer Wilson told us he didn't have any evidence of that despite the report. But to answer your question, I think this is where the nuance comes in. It's not only did the state actually prove the scope of Dropbox search, all right? And Officer Wilson testified in this case, unlike Burwell, that he didn't know what they looked at.
But the Dropbox, why couldn't the magistrate, or why couldn't we believe the Dropbox actual tip rather than what Officer Wilson knew or didn't know about?
You know, and that's a factual finding, it's entitled to deference, and I understand that. But that's where the second part comes in, which is what did Officer Wilson actually know? If we look at Jacobson, the Supreme Court's telling us the reason there was no problem, no Fourth Amendment violation there, is because there was a virtual certainty that nothing else of significance was in the package. I'm going to skip forward a little bit. That would not tell him anything more than he'd already been told. All right?
And why isn't that true here with the
This
viewing the
is
entirety
why
of
it's
the
not
files?
true. This is why it's not true. Nothing in this report at all tells us what's inside those videos. There's on page 5 or 6 of the report, where NECMEC apparently reviewed the videos, it says that there has been apparent child pornography. That is the most that Officer Wilson knew here. He testified at the hearing. I had to watch those videos so that I knew there was actual child pornography.
So for a private search doctrine review to not pose a problem, what would a tip have to include?
Well, a lot of the cases we read has these descriptors like A1, A2, and it kind of tells generally what we're dealing with. We don't have that here, okay?
But are you saying you need that?
You need something if the officer is going to go further.
But how did the officer go further if Dropbox
Because-
viewed the entirety?
I apologize, but it's because he didn't have knowledge of what was in these videos by his own testimony.
Okay,
That's
wait,
why.
just walk me through this, because you know,
Sure.
in Jacobson, you got the
Right.
FedEx package with the cocaine, and
Yes.
so the government agents retest it. They're like, well, what is this white powder? Well, let's make sure it's cocaine. So why is that any different here for Officer Wilson to say, well, yeah, I need to look at it for myself and make sure that it's actually child pornography?
This is why it's different, and I would suggest the Wilson Ninth Circuit case, the Ackerman case, discuss it. Both of them discuss it. So Jacobson, although the whole, this is what we're ruling on, right? What they granted cert on involved this secondary test. What they did was two things. Number one, private search doctrine allowed the police officers to pull that packaging out and look at this powder. And then number two, they said the chemical test was not a search. The reason it was not a search is because the only thing it could tell is this contraband or not? But when you view a video, it could tell you anything. It could tell you it's not child pornography. It could have a political speech in there. We don't have any idea what's in there until we review it. So it's a little bit confusing, but the Wilson and Ackerman cases both describe it. That field test that's done in Jacobson is actually not a search. So that's the difference there.
Okay, but I understand chemical test, not a search.
Right.
However, the rest of what you just said, it kind of seems like you're reinforcing my point, actually, because if you have the idea that this video might be illegal, and then the officer says, well, let me look at it before I take any law enforcement action to make sure I think there's a problem here, then they're going to have to re-review it. So,
Well, first of all, there is a way to re-review it, and that Justice Gorsuch talks about it in Ackerman. They could have most likely got a search warrant to view the files themselves. It's an extra
Right.
step in the process.
So how does that work? 'Cause I'm confused here. Why get a search warrant at all? If the private search doctrine applies, and so under the state's theory, the private company reviews the files and then tells NECMEC, who can then review the files under the private search doctrine as long as you don't go beyond, And then if the police can review the files, as long as you don't go beyond, why get a search warrant at all?
It's a good question. And the result in this case would probably be the same thing. The search would fall or, rise on the application of the private search doctrine. But to be safe.
But it wouldn't make them safe, because if the officer exceeded the scope of the private search doctrine, or if they were a governmental agent,
Right.
then the fruits of that initial review would be out anyway, and so the later warrant wouldn't help.
Certainly the government agent part, you're correct on. But what I'm saying is, with a simple step in between.
Right, you're saying they could have gotten a warrant.
They could have protected themselves.
Does any law say they have to have gotten a warrant though?
Well, the reason they have to is not violate the Fourth Amendment in the particular circumstances of this case.
Okay, let me just bring you back to, so our court, and this is binding precedent on us in Burwell, describes the test on agency, as whether this is a Dropbox is acting as a private party or a government agent,
Right.
as having two factors, both of which you have to prove were met under Burwell.
Yes.
One is knowledge of an acquiescence in the intrusive conduct. We've been talking about that. And the second is that the party performing the search intended to assist law enforcement efforts instead of to further its own ends. And I know we have the contracts here.
Mm-hmm.
Can you tell me, is there anything in this record that shows, that goes on that second factor, that tells us what the intent of Dropbox was here in reviewing these files?
Yes. I want to first mention, even with those two elements, the two-factor test, the second factor, if you look at Ackerman, I know it's not binding on the court, but it explains the fact that there's some other reason you might be performing the search in your own, for your own needs, for your own purposes, doesn't vitiate the agency test, okay? So I think the two important factors are, number one, whether or not the government knew of and acquiesced, and number two, whether or not Dropbox intended to assist law enforcement. And this is how you get that. Number one, I would point out that Dropbox, and even if they're actually reviewing these files, they're violating federal law. They're violating state law. There is no law that allows a private actor to do this at all. I mean, there's no exception, which is the classic police function. The only way that they're not violating the law is if it's part of the police function. The other thing that we have...
But maybe they are. Why does that change the outcome in this case?
Well, it goes to show that they're intending to further the search for police purposes.
Because if they were doing it for their own purposes...
They have problems.
But there are countless cases
But there is another, other than the agreements. And the agreements, it's not in the state's briefing, but it requires them to search their clients' files. The other thing we have...
But it doesn't say anything as to motive. None of that. They agree that they will search, but there's nothing as to how often or what they're going to search, and there's nothing as to why they're going to search.
The beginning of those, at least two of the agreements do lay out that NECMEC's purpose is to assist law enforcement, number one. But we also have to remember we have the emails, all right? If you look at our subpoena in this case, you'll see that the reason we got that email is we asked for anything from NECMEC specifically discussing Mr. Rosales' case. So we got essentially one email. The email says, from NECMEC to Dropbox, essentially, thank you for assisting us in our mission, something along those lines. It then follows up with a list of 400 cases, I guess for the month of December or the months of the end months of 2020, where NECMEC is telling Dropbox, here are all of your leads, here are when those people were arrested. Also, for all other service providers, when the tips were made, who made the tips, whether or not they are arrested. And they also report, hey, there's 466 other cases that we've given over to police, and we don't know what happened with those. So when you're looking at agency, I know that this court in Burwell selected an agency test. But if you look at all the Supreme Court cases that we've cited, if you look at Ackerman, the really thorough review of the agency test, number one, we think we meet the Burwell test. Okay, let me leave it there. But number two, we look at the close and continuing contact between law enforcement and this private party. And the fact that, as the district court said, we don't know how Dropbox did their initial search. We don't know if they used photo DNA, and we don't. They had good lawyers and they outfoxed us, and we didn't get what we were looking for from Dropbox.
So we don't know who did what inside Dropbox?
We don't know who did the initial search, okay? or how they did it.
Wait,
But
so do we even know if it was a person who did the initial search versus a computer program?
I don't think it was proven how the initial search took place at all, quite frankly.
Okay.
But the district court said the defense didn't prove that photo DNA was used in this search. But here's the deal. If you've got a government agent and you're working closely, this agent's working closely with the government on hundreds of cases a year, that's enough to meet the agency test.
Let me just ask you, coming back to, we talked about intent, and I know we're going over, we'll make
And
sure
I'm
you get
over
the
my
same
time.
time.
I
But
apologize.
quickly on the knowledge and acquiescence piece, can you help me understand, based on existing law, ideally binding law, but just on existing law in general, is knowledge and acquiescence general or is it specific? Do you have to have knowledge of this search, or do you have knowledge of that there could be I mean, how do we understand that, and on what legal basis?
I would like to give, if I could have one more minute, an analogy. Okay? And the analogy I've come up with, and I think it fits, is a neighborhood watch that has an interest in getting drugs out of their community. And the police also have an interest in getting drugs out of their community. And so they take all the members of this neighborhood watch, and they say, we're going to give you our new technology. You can scan houses and it'll tell you if drugs are in there. And over a year, I guess 6 years here, if you look at the agreements, that's going on. And the neighborhood watch is reporting to the police, here's drugs, and the police report back, hey, look at these 400 busts we made at the end of this year. And they're doing that constantly, okay? Now let's assume that I go out, I'm part of the neighborhood watch, and I don't use my technology that day. I go out and knowing the police are going to look into my tip, because I'm an agent, I'm working for them. I go and I just peek in somebody's window. I see marijuana growing and I turn it over to the police. The question for the test is, was I acting as a government agent? I don't think it matters that the police know exactly what I'm doing. Here, NECMEC doesn't have to know we're going to search Mr. Rosales' Dropbox. They need to know I'm out there searching. I have an agreement to search, that I will search for this. I will set up processes that I will search, and I will agree to give this over to you. That's enough. It doesn't have to be, hey, you go look at Mr. Lander's house and see if there's drugs in there. I can have a roving agent.
And what's your
That's
best
our answer.
case, Ackerman?
I think the facts of this case are a little bit different than all of them. I mean, it's very fact sensitive. I think that Ackerman and Wilson give the best description of the law. Quite frankly, I think the Fifth Circuit case that went the other way, Reddick, it gives a similar description of the law. It points out that this private entity test involves the knowledge of the police officer, and is he gaining additional knowledge? It points all that out. It comes out the other way. The difference with Reddick is we had a little bit more information about what was in those files because of the designation, the A5 or whatever.
I thought Reddick was just hash values, whereas
It
here
was.
we have viewed the entirety of the files.
But my point is, I think that from Officer Wilson's standpoint, what knowledge did he have? He had this report. This didn't tell him any more than an A1 designation on a hashtag.
All right, I think we've got
Thank
your
you.
opening argument.
Okay,
You'll
thank
have
you.
time for rebuttal. Nobody's going to go home feeling
Okay.
like you got shortchanged.
And I apologize for going over.
No,
so
thank you. It was very helpful.
Yes.
Thank you.
All right, Ms. Hudson, we'll hear from you when you're ready. You're going to get 2 minutes of the no-fly zone. So.
May it please the court, my name is Heather Hudson. I am an assistant district attorney for Harris County, and I represent the state of Texas. This case does raise some interesting Fourth Amendment questions. When a private electronic service provider searches its users' files and discovers child pornography, and then, as they are required to do by law, conveys that information to NCMEC and a cyber tip. Ultimately, I think what this particular case boils down to is the fact that in order for the appellant to prevail on his claim that the search warrant is invalid because it's based on information acquired during a search that did not have a warrant and that violated his Fourth Amendment, it is still his burden, I think as you pointed out, Justice Caughey, that he has to actually establish that there is a search for Fourth Amendment purposes. So we have to initially at least implicate the Fourth Amendment. So what that means realistically for him is that he's going to need to show a couple of things. He's got to show that there is an intrusion upon some, information that he has, which he has a legitimate, reasonable expectation of privacy in, and that search was conducted by a government agent. Here, obviously, I don't want to go too much into standing, but the state certainly doesn't concede standing. It wasn't stipulated to or conceded by the trial prosecutor. I think if you read the record closely, the trial prosecutor is simply inquiring as to whether or not the defendant was going to establish that the Dropbox account belonged to him. The state doesn't dispute that generally people have an expectation of privacy in like a Dropbox account or some sort of electronic storage account. But I do think that there is a distinction between general information that's stored and illegal child pornography that an individual would then decide to remove from the safety and the secrecy of his own private storage device and then voluntarily choose to upload this to a third party, servers. I think there is a legitimate question there as to whether or not society would recognize as reasonable a defendant's belief that none of the information, which is illegal, that he uploaded, that the electronic service provider is not going to ever see that or ever disclose it to law enforcement. So
how could we decide that here when we have an agreement, but we don't know if it's the applicable agreement from the right time period?
I'm sorry, which agreement?
Between the user and Dropbox.
Okay, yes, and that's an excellent point. Ideally, it would be lovely, again, if we had the terms and services that applied when he registered. But again, I think that kind of switches the burden to the state. So I think really it was incumbent upon the appellant, if he wanted to show I was justified in having this belief that the information that I uploaded, which is child porn, nobody, even though this is going to a third party, which can store or share that information with other people, there's no way that they could ever scan the contents of my files. So again, typically, like here again, the 2022 services, terms of service, I think those are just illustrative of the fact that these are the types of conditions that Dropbox imposes. It does warn users you cannot store child sexually exploitative material on our platform, and we do employ automated technology to find it, and we can disclose it. So the state would argue he did, I think, have some sort of a burden to show when I decided to put this information out there that could get me in a lot of trouble, I was led to believe that this could not be, shared with anybody else. And tellingly, he doesn't do that.
I have a follow-up question about that, because certainly the fact that we found child porn suggests that, and it's harder to make the argument that he has expectation of privacy in something that was found that was actually contraband, right? But on the other hand, what guardrails can we put around the private search doctrine in this instance that doesn't just basically give Dropbox a license to scan anything they want at any time with the, because there might be pornography or other type of contraband, and essentially in run around the entire Fourth Amendment? Where does this stop?
That's an excellent question, and I think that's why we are seeing the emergence of hash value matching technology, because the idea there would be this search is a search that doesn't implicate the Fourth Amendment because, well, for instance, in United States versus Lowers, which is non-binding, but I thought it provided a very instructive analysis about what a search means in this context. So when an ESP is using hash value matching technology, the hash value that is assigned to that image has already been determined with almost absolute certainty that it is going to be a digital fingerprint that matches another image that has already been determined.
But there's a potential wrinkle for your side with that, because right now there's a circuit split, right? You have both Wilson and Mayer, the Ninth Circuit and Second Circuit, saying that doesn't count. Basically, if it's just a hash value match, then the private search doctrine wouldn't allow what happened here, where the officer went on to view the files, and then you have the Fifth Circuit and Sixth Circuit going the other way. My understanding was that we didn't have to reach that here because it's clear that in this tip, that the entire contents of the files were reviewed.
Yes, I think that's correct, and the point I was just trying to make is I think that's why companies are using that kind of technology, because they're trying to, kind of like with a dog sniff, it's a binary search that doesn't reveal anything but yes or no, this is not contraband.
But here, you wouldn't take the position that only hash value, that this record would suggest that only hash values were reviewed.
No.
And is it just because of that entire contents language, or do you have anything else you can point us to?
Right, I think if we are looking at the record in the light most favorable to the trial court's ruling, which is what we should do, we're talking about the private search doctrine. I mean, we have Officer Wilson's testimony. I visually inspected each of these files. The cyber tip report itself says that somebody at NCMEC viewed each of these files, and then it also says that Dropbox, an analyst, viewed each of these files in their entirety. And I understand that Officer Wilson testified. I don't know if that phrase means that somebody, like for instance, if it's a video, I don't know if they watched the whole thing. I know that they laid eyes on it, and then presumably they watch it until they confirm, yep, this is child pornography. But I think what the appellant is trying to do is use kind of non-evidence or the absence of evidence as proof positive that means that the analyst at Dropbox did not actually view the entire contents of the video. And I don't think that's a logical conclusion to reach when the cyber tip itself says an analyst viewed the entire contents of this file. I think it means what it says. And not to say that there are never inaccuracies in a cyber tip report, but we do afford, a greater degree of trustworthiness and deference to.
Okay, can you talk? Sorry. Can you talk about? Mr. Landers said that although we're following the Burwell test because it's binding, that this intent prong really isn't fully. I don't want to mischaracterize his words, but that you really focus on the bigger picture knowledge piece. Can you talk about that? Do you agree, and why?
Well, I think he's relying primarily on non-binding 10th Circuit, I think Ackerman's
10th Circuit.
And so really here, the only case I can really point this court to that is somewhat on point and binding would be Burwell. And that has the two prongs, and the defendant has to meet both of those. So here, the state would not concede that the contractual agreements show that the government knew of and acquiesced in the search. And you raise an interesting question about, does that mean general knowledge, or like do they have to specifically know? Like, did NCMEC know Dropbox was going to search this client's files? And I don't really know because we don't have anything on point for that. But ultimately, if he doesn't also then demonstrate, I think he could maybe meet that prong if he showed that there was something in the contract which compelled Dropbox to always conduct a search of its files using the proprietary photo DNA technology. And at least the way I read the contractual agreements, it doesn't support that. I think these show kind of a voluntary understanding that if Dropbox wants to use the photo DNA technology, they can, and there would be a sharing of information, but there's nothing that compels them to do that.
Right, so if I tell my staff attorney, here's Westlaw, you have this tool, but I don't say how to use it, when to use it in this case, under your reasoning, that would not show either knowledge or acquiescence? I mean, the test says knowledge and acquiescence, so I guess
right,
they need to prove both, but is it your position it wouldn't show either?
Right, I mean, in Burwell, all we know is that the officer testifies. I didn't know that, Adobe was going to search this guy's files. But yeah, knowledge and acquiescence in the terms of we then knew, like Dropbox would search every client's files and turn over that information to us. We don't, I mean, this case is an excellent example of why we don't have that, because the appellant did not make you know, the critical piece of evidence that they had to show in order to prevail on this claim, which is we don't even know how or why the search was conducted. So if he can't even show that Dropbox used NCMEC's proprietary technology, it's difficult to envision how they're acting as an agent of NCMEC. For all we know, Dropbox has hired, you know, Bob Smith to have the worst job in the world, and he just manually reviews all the user accounts to look not just for child porn, but for, you know, there's a host of other things that Dropbox prohibits its users from having on their site. So without showing, you know, that the technology was used, I don't see how he can ever meet his burden to show that Dropbox is an agent of NCMEC.
Oh, but the agreements say that Dropbox is agreeing to use this technology, right?
I think the way that I interpret the agreements is Dropbox of its own volition can use the technology. It can access the shared database with the hash values that NCMEC has, but I think I said in my brief, the agreements explicitly say Dropbox is authorized but not obligated to access this information. And there's a host of different circuit courts that, which are not binding, but that have kind of looked at cases where there's an even stronger evidence of participation between an ESP and NCMEC. And the fact that there was participation and sharing of information and technology did not transform the ESP into an agent of the state, because you can have mutually overlapping interests and still have the ESP pursuing its own private business interest and not wanting child porn.
Is there
and the
any
email
evidence?
that we heard about?
I'm sorry?
The email that we heard about? I'm trying to remember the exact language.
I'm sorry, Your Honor, I can't remember the exact language of the email.
It was like, thank you for
Assisting.
assisting. It was listing all of these different,
The confirmation from NCMEC, that was,
Okay.
is that what you mean? Yeah.
I would tend to say that's fairly superficial evidence of assistance. I mean, almost anything could be assisting. And in other cases, there's quite a bit of assistance. I think, and I can't remember the name of the case, but in one case, the ESP, I think, actually helped do something to improve the technology or something. And that, again, does not render them an agent if they have their own kind of self-interest.
what in the record here shows their own interest? I mean, we have all this background case law with courts saying these companies have their own interest. We have Officer Wilson saying, in my experience, these companies have their own interest. But is there anything in this record that actually shows that Dropbox had its own interest beyond this kind of generalized idea?
I think there is, but I would also point out that I think it's actually the appellant's burden to show that Dropbox did not have its own interest. But here, I think if you look at the terms of service and their acceptable use policy, and the fact that they do require that none of their users can have child porn on their sites, and that they're essentially touting the fact we don't allow criminal activity on this platform, which makes them more reputable and therefore more attractive to consumers. I mean, in every case that I've come across, that's always the, you know, private interest that the ESP has.
And why can we look to the terms of service that are not from the applicable time period that Rosales would have signed them as evidence or not, and why?
I think definitely for this specific issue, because I don't know that we're looking at exactly at this time, did they have a private interest? It's in general, does Dropbox have a policy of wanting to keep, you know, illicit criminal activity off their platforms? And I think so, Your Honor.
Okay, I have related to this. If Dropbox was a private party and the private search doctrine applies, what was the need for the warrant? Was that just to go see what else might be in the Dropbox account? And if I think the state's brief said that the rest of the Dropbox account was searched. Did any other contraband show up in that search?
That's a good question. I think there's an upload log that shows quite a bit of videos and some pretty graphic titles describing those videos. Whether or not that was used in the charging decision, I'm really not sure.
Well, can you help us understand the decision tree here then? Because as I was saying earlier, it doesn't, if we don't agree with you on the private search doctrine, if we think either Dropbox was a government agent or that the search exceeded the scope, the later warrant doesn't save because the officer reviewed the files before the warrant, doesn't save it.
Mm-hmm.
And if we agree with you that private search doctrine controls and the search didn't go beyond, why do we need to reach the Franks issue and the warrant, whether it solves probable cause? Why is the warrant still relevant, kind of either?
I think it's always best practices to obtain a warrant before you then would go and search the entirety of someone's Dropbox.
No, I understand why the police would have wanted a warrant to go search the entirety. I'm talking about in this case. Why would we be writing, in kind of either way, why do we reach the Franks issue? Right, like from your side, let's say we agree with you, and I'll ask Mr. Landers the same thing, but if we agree with you and we conclude private search doctrine applies, no exceeding the scope, no government agency, if nothing beyond these 9 files at issue in the private search doctrine were introduced at trial, why do we
care about a Franks analysis?
Yes.
Oh, that's an interesting question, honestly, one that I hadn't pondered. If the court feels it doesn't need to determine whether or not the affidavit had enough facts to establish probable cause, the state would certainly be okay with that. All I can say is that I think typically the officer would want to get a warrant. Like in this case, well, the appellant wouldn't concede this, but in this case I think it's clear that everybody has viewed the exact same things and everyone has confirmed that it's contraband. But in a different scenario where maybe the ESP was just using hash value matching technology and there's a 0.01% chance that the apparent or suspected child pornography is not child pornography, then the officer would want to go ahead and visually confirm that and then use that information to obtain a search warrant.
Okay, follow-up question on exactly that. If the officer believes that maybe the Dropbox review viewed the files, but maybe not in their full entirety, and then the officer wanted to watch an entire video where someone maybe just watched the first few seconds and realized it was problematic, is it your position that they would need a warrant to view the rest of that video?
Oh, okay, if I understand your question correctly, it's if the ESP viewed like a minute of the video,
Mm-hmm.
saw child pornography and then did not view the rest,
Mm-hmm.
would the officer need a warrant to
view the other 7 minutes or whatever?
Would it be exceeding the scope?
Or is it enough to say, this is a child pornography video, we reviewed it, you reviewed it, private search doctrine applies? Because there's really no new information being established that it's child pornography, we're just checking, which is it? Are we checking the same information or are we getting new information?
Right, and I can't recall the name of the case off the top of my head, but there was one that was kind of indicating that in terms of obtaining more information, I think what they were looking at was whether or not there was more information that the state could then use to obtain a warrant or to prosecute the individual. Is there a scenario where the ESP views 1 minute of a video, confirms, yes, this is child pornography, this is contraband, but then there would be additional information that they didn't see in the video that could then be used to prosecute? I don't know, I don't really think so. I think once you have contraband, it's contraband. I think most cases tend to treat it that way, and ultimately here, at least based on our facts, I know that the court has to tackle that issue since, based on the record, everybody is looking at the same thing. And it would be the appellant's burden to show, no, the ESP, even though the cyber tip says the entire contents of the file were viewed, you need to present some evidence to contradict that.
Coming back to kind of what acquiesce means, the knowledge and acquiescence problem, what do you think is your best case for us to look to?
As far as acquiescence, Really the only case I would keep encouraging the court to look at is obviously going to be Burwell. How instructive Burwell is as far as acquiescence, I don't know.
Well, there they said there was no evidence, and here you have these agreements. So does that matter?
Well, even assuming that it did, it doesn't mean the appellant meets the second factor of that test. But in terms of how federal courts, other cases have treated it, I guess I would refer the court to United States versus Stevenson, I believe, and there, there's quite a bit of an exchange of information and cooperation, and so again, I don't think that case necessarily had the contractual agreements that we have at play here, but the idea being, if the contractual agreements are just showing an exchange of information, which happens to help both parties, but one party does have a separate, reason to do it aside from just assisting law enforcement, then that would not, automatically render the ESP a.
So what if the agreement said Dropbox will search every user every week? Would that change the analysis? Would that be enough?
That's a good question. I don't know. I think the appellant would have a stronger argument, but even then, I don't know if there's any mechanism in place for NCMEC to enforce that. I don't know that NCMEC can compel Dropbox under that scenario to actually search all of its files and then provide that information to NCMEC.
But here, I guess it could be consistent with the agreement that Dropbox searches once a year, or just some files, or no? Yes or no? Under these agreements, could it be that the Dropbox uses this? It agrees to use this technology. It's voluntary, but it's agreeing to do it. Under the terms of this agreement, could Dropbox in fact only use the technology once a year?
Yes, and Dropbox could use somebody else's technology, or they could use somebody who just manually inspects things. So again, I just read these as an agreement that you can have access to this, you can use it. If you're going to use it, we'd like you to update us with your progress. That way we can refine the technology, but I don't see anything that makes it mandatory on Dropbox to actually conduct these searches.
Okay, and what about, is there any, do any courts look at constructive knowledge in this context? Like with my example, if I give my attorney Westlaw, is there constructive knowledge once I give you the tool that you're going to use the tool, or no? Is it really just fact specific on what these agreements say?
Not that I'm aware of, Your Honor.
Okay. With only 2 minutes, I'd like to briefly take you. We talked about a little bit about Franks, but we didn't talk about the details of Franks, and I just want to make sure I kind of understand the outlines. The most concerning fact to me that's removed is the date and possible staleness arguments, and so. Just to make sure that I understand, I'd love to kind of point out my understanding and have you walk me through why I'm right or wrong. So in terms of the dates, the only dates we still have now are the September 2019 search warrant date, and then we have a date stamp referring to May 2019 in the tip, which means in the cyber tip. So we then have some knowledge that the tip couldn't have happened, I guess, before then, because Dropbox wouldn't have been able to see into the future. Are those the only dates we have, and can you, do we even have both of those dates? And can you walk me through the staleness analysis from your perspective?
I think we do have both of those dates, and this is where the appellant and I would obviously disagree, because I think his argument is that because the upload date of the files is inaccurate in the affidavit, that means that the entire paragraph that clerical error is in essentially gets tossed out with everything else.
Not just the date, but the
right. And that paragraph would include, if you read it generously, that the date of the report was, I think, May 28th of 2019.
Right.
And so in the trial court's findings, it considered that and determined that a magistrate could reasonably infer that the files were uploaded, sometime in close temporal proximity to the date.
But how do you have any evidence on when the files were uploaded? I mean, what if they were uploaded 10 years ago? What in this record shows when they were uploaded?
There's nothing in this, at least in
In
the
this affidavit, sorry, the four corners of the affidavit.
If we're just looking at the affidavit, there's nothing that would indicate the date that it is uploaded, other than just if the magistrate can infer that typically, the ESP, when something's uploaded, is going to be spotted and then.
But is there any reason, why would it be a reasonable inference that the ESP, we just talked about how in these agreements gave Dropbox the ability to search potentially all the time or not very often. So how do we then have a reasonable inference that Dropbox would have been searching often, number one, and then number two, does this really matter though, because we have the date of the NCMEC tip.
Right.
Oh, I didn't say that. We have the NCMEC tip date and we have the search warrant.
Yes,
right?
and so.
So the files were live, were still in existence then. So even if they were uploaded 10 years before, does that matter or not, and why?
I don't think it does. Ideally, it'd be better if we had the upload date in the affidavit, but I think it's important to keep in mind probable cause is a pretty low hurdle, and so really all the magistrate is looking for is, do we have a fair probability that contraband is going to be found in the place to be searched? And so, like, even if we don't have that date, we still know this tip is forwarded at this time. The officer reviews these files. He confirms that it's contraband. These files are associated with a specific user account for Robert Rosales at a certain service address. And then we also have Officer Wilson's attestation that Dropbox preserves the contents of the account after they make a cyber tip. So is there a fair probability that if a search warrant is issued, they're going to find child porn in that location? Yes. If there are no further questions, I'm losing my voice, so I will cede my remaining time to the court and ask that the trial court's ruling be upheld. Thank you.
Thank you. Mr. Landers, you have no expectation of silence from us during the first 2 minutes.
Well, let me first address a question that was already addressed or brought up by Justice Caughey. Why address the Franks issue? The reason why is if the court got it wrong even on the Franks issue, then whatever the government obtained via the search warrant would not be able to be used at trial. I'm going to be honest with you, I don't remember, there was 5 indictments originally. I don't remember if any of them were these same 8 files or not, but it would still raise an issue for us below.
So even if you win that this was a government actor or that search exceeded the scope, you're saying we have to address the Franks issue?
Oh, I think that if you decide on one of the first 2 issues in our favor, then you don't have to address Franks.
Okay,
now, if it got flipped up above, it would come back and maybe then you have to address it.
Okay.
But if you were to deny them, you should still address Franks, because it would, if the trial court erred in that and we go back below, we at least know in trial proceedings, keep in mind we pled partially because we lost the motion to suppress.
Right.
We have to then reevaluate whether or not this is the case we could plea without any of the information that came from the search warrant.
So you want to start on the date? Talk about the significance?
I would, and so to answer your question, I think there's one date in this search warrant affidavit, and it's the July 27, 2019, when Officer Wilson received the tip.
That's the NCMEC tip.
That's when he received the NCMEC,
Okay.
the cyber tip.
And that is in the affidavit.
That will stay.
Okay.
Every other date is out.
But why don't we have, didn't the tip also reference, when they were talking about the IP addresses, didn't it also reference, I know one of the IP addresses gets stricken under Franks, but didn't it also reference a May 2019 IP address?
I think that is on page 57 of the clerk's record. The May 27th date, right before screen/username, it's page 10 of the search warrant affidavit. That's also gone because
I'm not talking about the upload date.
Okay.
Sorry, I'm talking about the IP address.
Okay.
There were 2 IP addresses
Right.
identified in the tip, right?
And so I think to answer that question is, we have a May IP address being used.
Right, so we'd have to know that the tip had to happen.
Something needs to happen in May for that to matter. just like the January one where it falsely said, for example, if the January one had said January whatever, Robert Rosales at this address, well, that matches to something that happened in that Dropbox account. So what we've got left is just an IP address on a date with
Right.
no link.
Right, it does not tell us that he uploaded on that date or anything else, but we do know that the tip couldn't have come, that the tip couldn't see into the future. So the tip had to come on or after May
We agree with that.
2019. So we have a couple dates. We have the May 2019 or later is when Dropbox sent a tip to NCMEC because we have that date of the IP address. And then we have the July date of the NCMEC tip. But we don't have anything on when he uploaded these files.
Right.
It could have been 10 years ago. There's some law out there that in this type of criminal activity, people tend to keep these files, but that's limited. Usually it's not for unspecified periods of time. But my question to you, I guess, is help me understand how that matters, because if we know that these files were still in the Dropbox account in July at the time of the NCMEC tip, and then we have this preservation knowledge that Wilson says these companies usually preserve, and I understand we're striking the notice. Why, in terms of staleness, why doesn't that kind of answer the question that you would expect the files to still be there, whether they've been there for a month or 10 years before that?
Let me point out first the material omission, which is nothing happened in May. That's from the upload logs that Officer Wilson knew about. So that should be included in the analysis. But the reason is this. All we know is that the tip was received by Wilson July of 2019. That's it. Okay. We don't know what was in there on those dates. We don't know when NCMEC sent that tip over. That's just when Officer Wilson says he received it. And even if, I know we're not allowed to look outside the corners, but I'm not sure that's even the date that it was actually sent over to Officer Wilson. So maybe it's a difficult question because we agree, probable cause is a low threshold, but we think we need something, some date to anchor to where on this date, we know that there was child pornography in this Dropbox folder. And that's the argument. And the question for the court is what we have remaining enough? And we're suggesting it's not.
And is it really just a staleness question, or does it go beyond staleness somehow?
Well, I think staleness is related to whether or not there's probable cause to believe the evidence will still be there. So I think that is the question. Is there enough probable cause to believe when this search warrant in September is around that what Dropbox told NCMEC at some point prior to the middle of 2019 is still going to be there, when we don't know when it was searched by Dropbox. We don't know when Dropbox made the report to NCMEC. We don't know when anything's uploaded.
Well,
Can we consider?
Don't we know from the Ackerman case that that there's a rule that the ISPs have to preserve evidence once NCMEC confirms the tip. So could the magistrate not have taken judicial notice of that?
And that's in the warrant, and that part stays. The part where he says, I told them to keep it, that's out. But it's in there, and so that's something that the court has to consider, quite frankly. I'm just saying, don't just leave the pranks out of it. I would like to briefly just say, I would like to read another quote from Burwell, the court's own case.
All right, briefly.
Whether a private party should be deemed an agent or instrument of the government for Fourth Amendment purposes necessarily turns on the degree of the government's participation in the private party's activities. That's from your own case. You can rely on that. It's not just this one standalone test in Burwell either. The simple fact in that case is that there was no proof that these people were working together. And Justice Dokupil, I hope I'm saying your name correctly.
Dokupil.
Okay. Well, I apologize, but I would answer your question. How could this search have taken place? How can Dropbox search their users' files? Well, number one, they shouldn't have agreements that make it mandatory with the government, with a government agency, and that's what NCMEC is, to search their users' files. They can do it on their own, but the agreements that we've uncovered here change that analysis.
But the agreements don't say how often or when or any details, right?
It says you will, though. You will search your users' files and set up a process. It's in those agreements.
They're choosing to agree to do that, yes, but
Right.
we don't have any, so under these agreements, could they search once a year?
They have to report back semi-annually, but I guess they could report back, we only
We
searched.
didn't do anything, right.
They make the agreement to set up these processes, to do this, and then to give it over to Dropbox. There's another way that they could do it, even, I guess they couldn't do it with the agreement that they have. They need to do it for their own altruistic reasons, not because the government is asking them to, and they're agreeing to do it.
But why
another
couldn't-
way is for the officer to get the warrant in between, right? It's just an extra step. It's a step that didn't happen here. The final thing I would point out, I promise this is the final thing unless you have any questions. Page 7 of the NECMEC report states that these files had not previously been viewed or categorized by NECMEC. So in this case, I don't think we've got the matching hash, quite frankly. I think that's not even part of our analysis here. Just a specific fact that I've not seen in the other cases. With that, we ask that you overturn the lower court's ruling and remand back for further proceedings. Thank you.
Thank you very
Thank
much.
you.
Thank you to all counsel. The case is submitted, and we will stand adjourned.
All right.
Thank you.